Next section is 186, loan and investment by companies. Read along with companies meeting of board and its power rule 2014 says that not more than two layers of investment companies the company shall invest. So that is a threshold limit that you can only invest only two layers of the investment company. So company 1, then company 2, no more than two layers. This shall not be applicable to whose principal business is for acquisition of share debentures or other securities. Acquiring any company incorporated outside India if such other company has invested beyond the two layers of investment companies as per law of such country. यानी कि कहीं बाहर कंपनी इनकॉर्पोरेटेड हो वहाँ पे ऐसे इन्वेस्टमेंट अलाउ हैं. Other than that, for the requirement under any law. So if any sort of requirement under the law, you can go ahead and invest beyond the two layers of investment companies. Or investment to be made with the approval of all the directors at the board meeting and shall be approved by all the directors present at the board meeting. So board meeting में जितने directors हैं सारे approval देंगे. Talking about the limits, how much loan investment can we look into? No company shall directly or indirectly give loan to any person other than employee or a body corporate, give any guarantee or provide security in connection with the loan to any other body corporate or a person, and acquire by the way of subscription or purchase or otherwise security of any other body corporate subject to the limit of exceeding 60% of paid up share capital, free reserve and security premium, or 100% of free reserve and security premium, whichever is more. Providing loan to any person not an employee or a body corporate, giving any guarantee or providing security in connection with the loan or any other body corporate or a person, acquire by the way of subscription or purchase of any security beyond 60% of paid up share capital, free reserve and security premium, or 100% of free reserve and security premium, whichever is more, unless this is authorized by a special resolution in general meeting. This section is not applicable to, except for subsection 1, 2, banking companies established with the object of engage in the business of financing industrial enterprise or providing infrastructure facilities, to any investment made by investment companies made in shares pursuant to 162 section 1 clause A of another company, that is right shares, in respect of any investment of lending activities by NBFC whose principal business is acquisition of securities. Moreover, the exemption to the government companies engaged in defense production, government other than the listed company in case such company obtain prior approval of Ministry of Department of Central Government or State before such loan guarantee or providing any security or making of any investment. In the case the company do not have a share capital, then the computation of the limit is based on free reserves of the company. Now looking forward to 186 subsection 3, no special resolution is required where loan, investment, security or guarantee is to the wholly owned joint venture or acquisition made by a holding company by the way of subscription or purchase or otherwise a security of wholly owned subsidiary. The resolution passed at the general meeting to specify the total amount to which board of directors are authorized to give the loan, investment, guarantee, security or to make such acquisition. So I have to give the entire details. No company registered under section 12 with respect to merchant bankers, registrar to the issue, share transfer agents, talking about your any company which is registered under the SEBI, even its accrediting agency, or talking about the underwriters, they are not covered under this section, shall under such class of companies only the company registered over here can accept or provide loan, investment guarantee or security up to the limit specified in this section. So anything beyond this limit is not at all allowed. Moreover, there's a disclosure in the financial statement along with the full particulars with the utilization of money where all at it has been used. Now talking about the prior approval of financial institution where the loan is subsisting, there is required that it shall be approved by a financial institution, but subject to however, it shall not be required if it's within the limit of 60% of paid up share capital, free reserve, and security premium, and there is no default in repayment of loan installments or payment of interest as per the term of condition of the loan to public financial institution. Talking about the rate of interest shall not be lower than the yield of 1 year, 3, 5, or 10 year of government security closest to the tenure of loan. In case of Section 8 company, following shall be applicable. In a company in which 26% or more paid up is held by central government, state, or both of them, in respect of the loans provided by such company for functioning of industrial research and development project in furtherance object as stated in Memorandum of Association. Now, so this was the approval. Talking about the default with respect to deposits or payment of interest, do not provide investment loan guarantee security till the time such is subsisting, or anything which there is a default in 73 to 76, that is deposit. Register of loan shall be maintained and providing the details from the date of incorporation in form MBP2 entity entries to be made in chronological order within the 7 days of making such transaction. Register to be kept at the register office of the company under the custody of CS or person authorized in this behalf. Shall be authorized by CS or person authorized to authenticate it on every entry which is being made. Extract shall be provided to any member of the company on the payment not exceeding 10 rupees or as may be specified by the board in articles of association. Any sort of contravention, the company shall be subject to the fine of 25,000 up to 5 lakhs, or every officer a default, imprisonment up to 2 years or both, or fine 25,000 to 1 lakh rupees. So if I summarize, you should not provide loan security guarantee by the way of exceeding 60% or more of paid up share, free reserve, security premium, or 100% of free reserve and security premium. Whichever is more, you have to calculate that if SR is not passed. For companies registered under Section 12 of the SEBI, they are not allowed to exceed the limit. So there is no question of passing an SR on this regard. With respect to the non-applicability of the section is on the banking company, any infrastructure providing companies engaged and established with the object of infrastructure facilities, to any investment made by the company, investment company made in shares of the right issue, respect of investment जिसका principal business ही lending और guaranteeing loan से. Moreover, rate of interest हम discuss कर चुके. Then that is the quick go through. And the investment shall not be beyond more than 2 layers of investment company, subject to the exceptions already discussed. So that be all. Thank you.